Hello everyone, my name is Andy DeBolder and I work for the U.S. Fish and Wildlife Service. Welcome to the overview of the proposed revisions to the Endangered Species Act implementing regulations and the Code of Federal Regulations Title 50, Part 17, 402, and 424. On this slide, counterclockwise in the upper right, the photo montage includes images of a loggerhead sea turtle, bull trout, California tiger salamander, Heinz emerald dragonfly, and the emblems of National Oceanic and Atmospheric Administration's fisheries, also referred to as NOAA fisheries, the U.S. Fish and Wildlife Service, and Department of the Interior. Today, my colleagues and I will be providing an overview of three proposed rules that propose revisions to the Endangered Species Act, also referred to as the ESA, implementing regulations. Two of the proposed rules are joint rulemakings with the U.S. Fish and Wildlife Service and NOAA fisheries. Those are the listing and critical habitat regulations, which are in the Code of Federal Regulations, Title 50, Part 424, and the interagency consultation regulations in the Code of Federal Regulations, Title 50, Part 402. The third proposed rule is the U.S. Fish and Wildlife Service only rule that proposes revisions to prohibitions to threaten wildlife and plants in the Code of Federal Regulations, Title 50, Part 17. All of the slides in this presentation have 5 images in the box on the left side of the screen. From top to bottom, they are Kirtland's warbler, Sonoran desert tortoise, California least-turned chick, mission blue butterfly, and black-footed ferret. All 3 proposed rules will be publishing in the Federal Register in June of 2023. After publication, you can submit comments on the proposed rules for 60 days. We will provide information on how to comment at the end of this presentation. In January of 2021, the incoming Biden administration issued Executive Order 13990, which directed federal agencies to review regulations issued in the prior 4 years that may conflict with their priorities, including the use of science, improving public health, and protecting our environment. In June of 2021, the services announced their intention to revise 3 ESA implementing regulations that were finalized in 2019. Additionally, in November of 2022, in the resolution of litigation, a court remanded the same 2019 final rules to the services. First, I'll present an overview of the proposed changes to portions of the listing and critical habitat regulations in the Code of Federal Regulations Title 50, Part 424. I'll briefly discuss the proposed revisions to the regulations in the following topic areas: economic impacts relative to species classification, foreseeable future, standards for delisting, circumstances in which critical habitat designations may not be prudent, and criteria for designating unoccupied critical habitat. In the slides that follow, proposed additions to regulatory text are shown in orange, underlined font, and proposed deletions are shown in orange, strikeout font. We are proposing to restore the phrase "without reference to possible economic or other impacts of such designation" to the regulations in section 424.11b. Removal of this phrase from the 2019 regulations caused confusion regarding the service's intent for collection, presentation, and consideration of economic impact information when making ESA species classification decisions. The service is never intended to compile, analyze, or present information pertaining to economic impacts of species classification. Restoring this phrase to the regulations would address this confusion and remove this expectation. The ESA clearly requires that species classification determinations must be made based only on the best scientific and commercial data available. When Congress added this requirement to the ESA, they stated that determinations are to be based on biological criteria only, so to prevent non-biological considerations from affecting decisions. We are proposing to revise a portion of the foreseeable future regulations in section 424.11d. Specifically, we're proposing to edit the second sentence to read as, "The term foreseeable future extends as far into the future as the services can reasonably rely on information about the threats to the species and the species' responses to those threats." The edits to the sentence intend to more clearly explain the role of the foreseeable future concept in listing determinations and are consistent with a 2009 Department of Interior solicitor's opinion that guided the service's interpretation of the statutory term. Additionally, This proposed revision more clearly explains the appropriate role of the foreseeable future in listing determinations and avoids the appearance of setting a new standard for classifying species that could conflict with or cause confusion about the correct standard of the ESA when deciding whether a species meets the definition of a threatened species. Next, we propose to revise portions of the standards for delisting in section 424.11e by rewording the opening sentence of the paragraph by replacing shall delist a species if with it is appropriate to delist a species if. Removing the word shall does not change the meaning, process, or standards for delisting. We find that this proposed change would remove the potential for confusion or concerns that the services would take immediate action to delist a species without following required notice and comment rulemaking procedures, or that the decision to delist is predetermined in any way. We're also proposing to reinsert the word recovered to address concerns caused by the removal of this word from the regulations in 2019, and to appropriately acknowledge the species recovery as one of the principal goals of the ESA. Recovery planning and implementation and the ultimate goal of recovering threatened and endangered species continue to be priorities of both services. Lastly, we propose to remove the word same from both instances where it occurs in the sentence, stating that we must consider the same factors and apply the same standards when determining whether a species is recovered or no longer warrants listing. We are proposing this simple edit to eliminate any potential for unintended confusion that the analysis would be limited to considering only the same factors or threats that initially led to the species listing. By the time a species is considered for delisting, the particular circumstances and facts may differ from those that were occurring or operating at the time of listing. We are proposing to remove the following clause from the second circumstance of the regulations in section 42412A1. Threats to the species habitat stem solely from causes that cannot be addressed through management actions resulting from consultations under section 7A2 of the Act. We now conclude that inclusion of this phrase in the regulations gave the appearance that the services will presuppose the scope and outcomes of future Section 7 consultations under the ESA in order to make determinations that the designation of critical habitat is not prudent. This phrase also suggests that the only effects of a critical habitat designation are through the Section 7 process, which is not the case. We also propose to remove the current fifth circumstance that states the Secretary otherwise determines critical habitat is not prudent. Setting this text out separately within the list of circumstances in which the Secretary could potentially make a not prudent determination inadvertently gave the appearance that the services might overstep their authority under the ESA by issuing not prudent determinations for any number of unspecified reasons that may be inconsistent with the purposes of the ESA. However, because there may be unforeseen circumstances in which it may not be prudent to designate critical habitat for a given species, we're proposing to modify the wording at the beginning of this paragraph to indicate that the list of circumstances is not an exhaustive one. As we discussed in our proposed rule, and consistent with the ESA's direction to designate critical habitat for threatened and endangered species to the maximum extent prudent and determinable, both services will continue to expect that not prudent determinations will be rare. Lastly, we are proposing to revise the regulations in section 424.12b2 that set forth the criteria for a designation of unoccupied critical habitat. This slide shows the changes between the current regulatory text and our proposed revisions. The revisions we are proposing would better ensure that the implementation of the statutory authority is consistent with both the ESA and congressional intent. Specifically, we are proposing to remove the rigid requirement that occupied critical habitat be deemed inadequate to conserve the species before the services could consider whether any unoccupied areas are essential for the conservation of a species. We also propose other revisions to indicate that the services will, however, still begin their analysis by identifying habitats that are occupied by the species. Based on our extensive experience designating critical habitat, the most logical way to begin a critical habitat analysis is to start by looking at areas where the species occurs. This process has consistently been the practice of the services, regardless of which regulations have been in place. Additionally, we propose to remove the requirement that the Secretary determine with reasonable certainty that the unoccupied habitat will contribute to the conservation of the species and contain at least one physical or biological feature essential to the conservation of the species. We now find these requirements impose standards that go beyond and could potentially conflict with the science-based determinations required by the ESA. The reasonable certainty standard is also unnecessary in light of the best available data standard of the ESA, because this standard already inherently contains an obligation for both services not to base their decisions on information that is merely potential or speculative. We also now find that requiring at least one essential physical or biological feature blurs the distinction between occupied and unoccupied critical habitat, and that is clearly laid out in the ESA. Because the prior slide was quite busy, here is the complete proposed version of this section of regulatory text for the criteria for designation of unoccupied critical habitat. And it reads as follows. After identifying areas occupied by the species at the time of listing, the Secretary will identify, at a scale determined by the Secretary to be appropriate, specific areas outside the geographical area occupied by the species at the time of listing that the Secretary determines are essential for the conservation of the species. Such a determination must be based on the best scientific data available. And now I'll hand the presentation off to Marla Hamilton, who will discuss the proposed revisions to the interagency consultation regulations.
Thank you, Andy. I am Marla Hamilton, the National Marine Fisheries Service National Section 7 Coordinator, and I'm joined by Leanne Carranza, the Fish and Wildlife Service Headquarters Section 7 Policy Lead. We will be presenting information on the proposed revisions to Title 50, Part 402 of the Code of Federal Regulations. 50 CFR 402 establishes the procedural regulations governing interagency cooperation under Section 7 of the Act, which requires federal agencies, in consultation with and with the assistance of the Secretaries of the Interior and Commerce, to ensure that any action authorized, funded, or carried out by such agencies is not likely to jeopardize the continued existence of endangered or threatened species or result in the destruction or adverse modification of critical habitat of such species. The Fish and Wildlife Service and National Marine Fisheries Service share responsibilities for implementing Section 7 of the Act, and as such are jointly proposing these regulatory revisions. As a result of our review of the 2019 rule, we are proposing to make minor revisions to the definition of effects of the action and environmental baseline, clarify the responsibilities of the federal agency and the services regarding reinitiation of consultation, remove Section 402.17 other provisions in its entirety, and amend the regulatory provisions regarding the scope of reasonable and prudent measures in incidental take statements. The services are proposing these changes to improve and clarify the interagency consultation process. If finalized, these standards would apply prospectively. Thus, previous Section 7A2 consultations would not require reevaluation on the basis of the proposed revisions in the event they are finalized. I will now go into more detail on each of these proposed revisions. As a result of our proposal to remove 402.17, we are proposing to revise the definition of effects of the action as seen on the slide via the orange text. Changes include removing the parenthetical reference to 402.17 and moving the phrase, but that are not part of the action from Section 402.17 to the end of the first sentence of the definition of effects of the action. This allows the definition in subpart 402.02 to be self-contained and complete on its own terms without the need to reference additional sections of the regulations. It also allows the definition to retain the important concept as explained in the 2019 rule that activities that may be caused by the proposed action but that are not part of the proposed action are subject to the two-part causation test. We are proposing to revise the definition of environmental baseline to provide clarification, consistency in terminology, and address continued confusion. The proposed revisions are identified in orange and include replacing the term consequences with impacts in the third sentence to consistently use the term impacts throughout the definition for items that belong in the environmental baseline, while retaining the use of the term consequences in the first sentence for effects that are caused by the proposed action and not included in the environmental baseline. Removing the term ongoing to further emphasize that the action agency's discretion to modify is the determining factor when deciding which impacts of an action agency's activity or facility should be included in the environmental baseline. All actions, whether past or ongoing, that are not within the agency's discretion to modify are included in the environmental baseline. And adding the term federal to clarify the scope of the term agency. Although we are proposing to further modify the 2019 rules definition of environmental baseline for clarity, the practice of the services and our application of the definition in consultations will not change. Thus, the information and examples provided in the 2019 rules preamble remain relevant. The preamble for the proposed rule includes an application example and clarifies that we would expect the federal agency to clearly identify and describe with sufficient detail the governing authorities that may constrain their discretion over some or all of the federal agency activity or facility at issue. Absent unusual circumstances, the services anticipate we would likely defer to the federal agency's actions interpretation of their authorities. We are proposing to revise Section 402.16 to clarify the responsibilities of the federal agency and the services regarding their requirement to reinitiate consultation. The proposed revision is to remove the phrase "or by the service." This proposed change is to address continued confusion by courts regarding the service's authority to require reinitiation of consultation when the requirements for reinitiation have been met, even though in the preamble of the 2019 rule, we stated clearly that the services do not have such authority. We explained that reference to the service in that section does not impose an affirmative obligation on the service to reinitiate consultation if the criteria have been met. Rather, this reference has always been interpreted by the services to allow us to recommend reinitiation of consultation to the relevant federal action agency. We have information that indicates reinitiation is warranted. It is ultimately the responsibility of the federal action agency to request reinitiation of consultation with the relevant service when warranted. Note, the services may still recommend the action agency reinitiate consultation when a reinitiation trigger has been met. We are proposing to remove 402.17 in its entirety. As such, I am not including the red text on the slides. However, I want to address the key features of 402.17 and the basis for proposing removal in its entirety. The original intent of subpart 402.17 was to clarify that the reasonable certain to occur standard was to apply only to activities caused by, but not part of, the proposed action captured in the definition of effects of the action, and future non-federal activities under cumulative effects. The reasonably certain standard does not apply to whether aspects of the proposed action itself will be implemented. Although we are proposing 402.17 be removed, the concepts from this section are and will remain relevant considerations as noted by similar elements identified in the preamble to the 1986 Final Rule on Interagency Cooperation and the Service's 1998 Consultation Handbook. Section 402.17 also included a sentence intended to describe the nature of the information needed to determine that either an activity or a consequence is reasonably certain to occur. This sentence required the conclusion of reasonably certain to occur to be based on clear and substantial information using the best scientific and commercial data available. The introduction of the phrase clear and substantial information has inadvertently created the misperception that it represents an additional or different standard upon which to base a conclusion as to whether an activity is reasonably certain to occur. That was not our intent. The standard is the statutory requirement of using best scientific and commercial data available. However, the addition of the clear and substantial information requirement did not have the desired effect, and on reconsideration, we also find that it may be in tension with the statutory standard. The statutory preambular language that also describes this standard as requiring a degree of certitude, example given, page 44981, creates a confusion rather than promoting consistency in the application of how we determine the scope of effects of the action. Thus, we find that the information in 402.17 would be better suited for discussion in a guidance document rather than regulations because further explanation is needed on when and how these factors should be considered. We expect to address and expand on these factors in updates to the Service's Consultation Handbook. And as stated previously, we propose to capture the point in subpart 402.17a that the reasonably certain to occur standard does not apply to the proposed action itself, but instead to activities that are caused by the proposed action, through the addition of the phrase, but that are not part of the action, directly to the definition of effects of the action in subpart 402.02. This revision provides clarity and allows the definition of effects of the action in subpart 402.02 to be self-contained and complete without the need to reference additional sections of the regulations. Now I'll hand off the presentation to Leanne Carranza, who will discuss the last proposed revisions to the interagency consultation regulations.
Thank you, Marla. I'm going to cover the proposed revision to the regulatory provisions relating to the scope of reasonable prudent measures in an incidental take statement. All the other changes were in response to our review of the 2019 rule. This proposed change is to the service's implementation of the ESA, so it better reflects congressional intent and better serves the goals of the ESA. Our current practice and the position taken in the 1998 Consultation Handbook is that RPMs may not consist of measures that offset impacts from the taking of individuals through activities other than avoiding or reducing the level of incidental take. In addition, that RPMs must occur within the action area. However, this proposed change allows the services to consider for inclusion as RPMs measures that offset any remaining impacts of incidental take that cannot be avoided. Such offsetting measures are not an alternative to reasonable prudent measures that reduce or avoid incidental take, but rather are additional measures to address the residual impacts to the species that remain after measures to avoid and therefore reduce incidental take are applied. They are not required in every case. In instances where the impact to the species occurs as the result of habitat modifications or destruction within the action area and cannot be minimized within the project site or action area, offsetting measures could include restoring or protecting suitable habitat for the affected species, e.g. via a species conservation bank, conservation easement with endowment, in-lieu feed program, restoration program, etc. These additional measures do not modify the action subject to the consultation and may occur inside or outside of the action area. And offsetting measures would be considered for inclusion only in a sequence in which the services first considered appropriate measures within the action area. Also, offsetting measures, as with all RPMs, must be commensurate with the scale of the impact, subject to the existing minor change rule in 50 CFR 402.14 I2, and be reasonable and prudent, and be necessary or appropriate to minimize the impact of incidental taking on species. Now that we described the outcome of the proposed revisions to the scope of RPMs, I want to share with you the basis for the specific revisions to the regulations we are proposing. The Endangered Species Act Section 7B4 is repeated on the slide. It provides the requirements for issuance of an incidental take statement. This proposed change more closely adheres to the statutory language found here at Section 7B4B II at the bottom of the screen by using the terms minimize such impact. The proposed revisions include changes to the definition of reasonable prudent measures, changes that adhere more closely to the statute, including replacing the term believes with considers, and replacing the clause impacts, i.e. amount or extent of incidental take, with impact of incidental take on the species, to more closely track the statutory language at 77B4 on the previous slide. As you can see on the slide, that the regulatory language in 50 CFR 402.14 already provides that the impact on the species is to be specified in terms of the amount or extent of incidental take caused by the action. The proposed changes also include revising section 402.14 I, 1I, and II to reflect our interpretation that RPMs are not limited solely to avoiding or reducing incidental take and may occur outside of the action area. Lastly, a new paragraph at I3 is proposed to clarify that offsets within or outside the action area can be required to minimize the impact of incidental taking on the species and the sequence in which such measures will be considered, giving priority to measures that avoid or reduce incidental take, followed by consideration of measures that offset the remaining impact from incidental take on the species that cannot be avoided or reduced. As stated earlier, none of this is meant to imply that the services must require offsetting measures inside or outside the action area, only that they have the discretion to do so. To illustrate how offsetting measures might be applied under this proposal, assume a federal agency consults on its issuance of a permit for a transmission line. The service determines in a biological opinion the proposed action is not likely to jeopardize federally listed species. The project as proposed was designed to minimize impacts to the species, and incidental take would be kept to a minimum. When developing the incidental take statement, the service then considers whether any reasonable prudent measures could be applied within the action area to avoid and further reduce incidental take levels. Then the service considers whether any offsetting measures to minimize the remaining impacts to the species from incidental take could be applied, giving preference to offsets that can be applied within the action area. This offset would not be limited to the action area, and as mentioned previously, the offset could include the federal agency or applicant restoring or protecting suitable habitat for the affected species through, for example, a conservation bank. In closing, as stated previously regarding all proposed reg revisions, if finalized, these provisions would apply prospectively. Thus, previous Section 782 consultations would not require reevaluation on the basis of the proposed revisions in the event they are finalized. These proposed revisions also would not alter the way the impacts of incidental taking are currently specified in an incidental take statement. I will now hand the rest of the presentation off to Robin Niver, who will share the proposed revisions to 50 CFR Part 17.
Thank you, Leanne. My name is Robin Niver, and I work for the U.S. Fish and Wildlife Services headquarters in our Ecological Services program. And I'm happy to provide an overview of the Fish and Wildlife Services proposed revisions to 50 CFR Part 17. First, I thought I'd provide a little background on protections under the ESA or the Act to provide context for the proposed rule. Section 9 of the Act provides a specific list of prohibitions for endangered species, but does not provide these same prohibitions to threatened species. Instead, Section 4D of the Act requires that the Secretary issue regulations necessary and advisable to provide for the conservation of threatened species. These are referred to as 4D rules. Congress delegated the authority to the Secretary to determine what protections would meet this standard for a given species. Here's a little bit more background. The Fish and Wildlife Service developed regulations under Section 4D of the Act in the 1970s and 1980s, in which the default was that most endangered species protections would apply to threatened species unless we promulgated a species-specific 4D rule. We called these the blanket rules, and we had separate rules for wildlife and plants. These are Fish and Wildlife Service only regulations. National Marine Fisheries Service did not adopt a similar approach. The blanket rules referred to our endangered species regulations, but with some differences in protections for threatened species. Also, our endangered plant regulations were not updated after amendments to the Act in 1988. Therefore, any threatened plant species that referred to our endangered plant regulations did not actually have the same protections as endangered plants received under the Act itself. In 2019, the Fish and Wildlife Service finalized regulations that discontinued the use of the blanket rules for all newly listed threatened species. This change only applied to species listed after the effective date of the final rule in 2019. So none of the species listed in the past as threatened species for which we invoked the blanket rules were affected. Since the final rule became effective, the Fish and Wildlife Service has issued species-specific 4D rules for all newly listed threatened species. Now we'll discuss the proposed rule. We are proposing to reinstate the blanket rules, which would again apply the majority of the Section 9 prohibitions afforded to endangered species to any newly listed threatened species unless we issue a species-specific 4D rule. The availability of blanket rules would not change our ability to issue species-specific rules. We also propose to extend to federally recognized tribes the exceptions to prohibitions for threatened species to be able to aid injured or diseased wildlife or plants or dispose of dead individuals without permits. We also propose changes to our endangered plant regulations at 50 CFR 17.61 so that our regulations match the 1988 amendments to the Act. Finally, we propose multiple minor edits to improve clarity and consistency among the sections of our regulations. I will provide a little more detail in the next slides. The main change in our proposed rule is to reinstate the blanket rule options for protecting threatened species. These blanket rules include all of the Section 9 prohibitions that are applicable to endangered species, as well as exceptions to those prohibitions that allow various entities to conduct otherwise prohibited actions without the need for a permit. This includes things like allowing Fish and Wildlife Service law enforcement to handle illegally taken species and allow Fish and Wildlife Service, National Marine Fisheries Service, and states with cooperative agreements to aid or salvage threatened species or conduct conservation actions for threatened species. If we reinstate the blanket rule options, this will not apply as a default for threatened species. For every newly listed threatened species, we will determine what protections are appropriate, whether it is the blanket protections or a species-specific rule. This proposal would allow for a more efficient method to protect threatened species for which we find the blanket rule protections are appropriate. We are also proposing to extend to federally recognized tribes the exceptions to prohibitions for threatened species to aid, dispose of, or salvage threatened species. Here's an example of the regulatory text for threatened wildlife that is already applicable to the Fish and Wildlife Service, National Marine Fisheries Service, and state natural resource agencies with approved cooperative agreements with the Fish and Wildlife Service. Aid a sick, injured, or orphaned specimen, dispose of a dead specimen, salvage a dead specimen that may be useful for scientific study, remove specimens that constitute a demonstrable but non-immediate threat to human safety. We are also proposing to update our endangered plant regulations at 50 CFR 17.61 C1 to match language in the amendments to the Act enacted in 1988. This does not change the protections for endangered plants, as the Act already provided these protections. However, this revision will update the protections afforded to threatened species of plants protected under blanket rules. The proposed revisions include the prohibitions against maliciously damaging or destroying endangered plants on federal lands, or removing, cutting, digging up, or damaging or destroying the endangered plants on any other areas in knowing violation of any law or regulation of any state or in the course of any violation of a state criminal trespass law. In addition to the proposed regulatory revisions that I mentioned, we are also considering including an additional provision at Section 1731B and 1771B that would extend exceptions to the prohibitions to certain individuals from federally recognized tribes for take associated with conservation-related activities. These exceptions to prohibitions for threatened species are already afforded to employees or agents of the Fish and Wildlife Service, National Marine Fisheries Service, state natural resource agencies with cooperative agreements with the Fish and Wildlife Service. Adding this exception to the general prohibitions for threatened species may be appropriate and would demonstrate the Department of Interior and Fish and Wildlife Service's recognition that tribes are governmental sovereigns with inherent powers to make and enforce laws, administer justice, and manage and control their natural resources. In an effort to recognize our government-to-government responsibilities, secretarial orders, and recent executive orders, and recognizing the management efforts and expertise that federally recognized tribes bring to conservation of threatened species, we are considering this provision. While we are not proposing this language, we have included potential language in the preamble to the proposed rule. Here's an example of regulatory text that we are considering for threatened species of plants. Notwithstanding Section 17.61C1, and unless otherwise specified, any employee or agent of a federally recognized tribe's natural resource agency undertaking conservation activities in accordance with an approved cooperative agreement with the service that covers the threatened species of plant, who is designated by that agency for such purposes, may, when acting in the course of official duties, remove and reduce to possession from areas under federal jurisdiction those species. We are seeking public comments on this potential additional provision to help inform our final regulation. Thank you. That is the end of the 50 CFR Part 17 proposed rule. The proposed rules will be available for review and public comment for 60 days. Please note, we are also soliciting comments on all aspects of the 2019 final rule for the Section 402 and 424 regulations. Please make sure to submit your comments through regulations.gov. Links to the 3 proposed rules with details on how to provide comments are available on our website. After the public comment periods close, we will review and respond to comments and determine how best to finalize the rules with a target publication in spring of 2024. Thank you again. That ends the overview of the proposed revisions of our Endangered Species Act implementing regulations for listing in critical habitat, interagency consultation, and for prohibitions to threatened species. Thank you for your interest.